everybody to a last Friday lunch and learn. It's the last Friday of February and very spring-like. So with that in mind, I'm going to analogize this to being at spring training like Major League Baseball players, Mets and Yankees, so nobody's taking any sides here. But the point is, and some of you who may have heard me speak before know that I like this analogy because what it means is that Major League Baseball players, no matter how experienced they are, still go down to Florida every year and practice the basics and go over the very simple things that everybody needs to know and practice. And so today, we're going to do that. The title of the program is Basic Misconceptions in Wage and Hour Law. And I'm going to go over a few things that some of you probably know, but maybe some of you don't. But even if you know it, it's always good to hear it again and remember these concepts so that they're top of mind all the time. Now remember, these are misconceptions, so when we go through the title of the slides, those are the misconceptions, and then we'll discuss what the truth is. So let's begin. So the first misconception is that all managers are exempt. That is a frequent comment that I hear, that if you're a manager, you're exempt. Well, that's just not that simple. Managers do have to meet certain criteria. It's under the executive exemption. And as I point out here, basically, the primary duty has to be to supervise 2 or more employees. And it has to be in a recognized department or unit of the business. So that's a very important part. The manager must supervise at least 2 or more people. So if you have somebody who's a manager and is not supervising anybody or is supervising one person, they're not going to meet the criteria. And it does have to be in a recognized department or unit of the business. In addition, a manager has to make recommendations regarding hiring or firing, or actually do the hiring and firing, but it's sufficient to meet the test if they make recommendations regarding those decisions. And of course, they have to meet the required salary threshold. Now, frequently, clients will say, I have someone who's an accounts manager, and what it means is that they're usually in sales, and what they're managing, though, is accounts. They're not managing people. They're managing customers. And that would not satisfy the exemption, the executive exemption. So you have to manage people. That's the basics here. And while we're talking about salary thresholds, which I just identified, another thing to remember, maybe not a misconception because it's relatively new, but the federal salary threshold of $455 is what controls, because we all heard that the rules that were promulgated did not go into effect. Well, that's not true because we are here in New York State. And in New York State, there are different salary thresholds that apply. And it depends on where the employees are employed. And on this slide, I have put out for this year the salary thresholds that have to be met in order for an employee to be exempt. So you'll see the various ones, the top one, including Nassau and Suffolk counties. And there are grading upwards for the next several years. So this is all on the Department of Labor website. You can get that. For those who have any interest in New York City, large is only 11 employees. So if you're 11 employees or above in New York, you will have to pay based on this rate. So always please keep that in mind, even though those federal regulations did not go into effect. Next misconception, all salaried employees are exempt. And this is similar to saying all managers are exempt. A lot of people say all salaried employees are exempt, as if paying someone a salary is the only requirement to be exempt. Well, salary is a requirement for exempt status, but paying someone a salary doesn't make people exempt. It doesn't make a non-exempt employee exempt. The duties is what determines whether someone is exempt. So if you have somebody who is an admittedly non-exempt employee, perhaps let's say a maintenance worker, the fact that you pay them $500 a week or $1,000 a week isn't in and of itself going to make that maintenance person exempt. It is okay to pay that maintenance person a salary, but if overtime is implicated, then you will have to calculate the hourly rate nevertheless. So the point here is you can't just call someone exempt simply because you pay them a salary. Next, commission employees are exempt. Well, that seems to be, from where I stand, quite a misconception that inside sales employees are being treated as exempt by many, many companies. Well, inside salespeople, commission salespeople, are not exempt. There is, you may be familiar, of course, with an outside sales exemption, but a commission employee is not exempt. Commission employees, just like hourly employees, have to have their time tracked on a daily basis, and commission employees must be paid overtime. And this presents issues many times to business people who, want to have their salespeople working hard and working long hours, and that's how they generate sales and, of course, generate commission for the employee. But by doing that and having them work over 40 hours, you will still have to calculate an overtime rate that it would include the commission. So that is an important concept to keep in mind. And while we're talking about commission employees, verbal commission agreements are okay. And remember, again, what's up on the blue are the misconceptions, okay? Verbal commission agreements are okay? No, they are not okay. And this is New York specific. Commission salespeople are required to have a contract, a written contract. And the written contract must contain all the details of the specific arrangements that are in place. So they must have the percentage commission that they're going to be paid, at what time they're going to be paid, when the commission is considered earned, and any other circumstances that may relate to commission employees must be in writing. Now, if you do not have an agreement in writing with a commission salesperson, then what happens is if there's a challenge to the arrangement and the commission employee says, well, you were supposed to pay me X, and you dispute that, if you don't have a written agreement, then the presumption, a legal presumption, will exist in favor of the employee's version of what the arrangement was. So in order to avoid being in that very compromised situation, you want to be sure that you have all commission arrangements in writing and signed by the commission employee. Overtime is based on the pay period. No, overtime is based on hours worked in 1 week. And I still see payroll records that show 80 hours each pay period without breaking it down on a weekly basis. And if a company has payroll records that show it that way, then that would be something that would be identified in an audit and could present a problem, because even though someone works, or their typical work week is 40 hours per week, and you are recounting or counting the payroll record reflects, I should say, 80 hours, we all know that that doesn't always have to add up that way, because if you work, let's say, 45 hours in, well, 55 hours in week 1, they could work 25 hours in week 2. They're still at 80, but they would be owed 15 hours overtime for the first week. So it's important, and you may even if your payroll records say 80, it's possible that you are paying it correctly, but the idea is that the payroll records aren't reflecting it accurately, and that would definitely present a problem if you were audited by either the federal or New York State Department of Labor. It's okay to not pay for unauthorized overtime. Well, you know, many companies, probably most companies, have a policy that prohibit overtime work without prior authorization. And that's a good policy to have in effect. You definitely want to control overtime. Employees don't have the right necessarily to work overtime, especially if the company isn't aware of it. So we absolutely recommend that you have a policy saying that you cannot work overtime without prior authorization. And you can say that the violation of that policy will be disciplined. You're subject to discipline up to and including termination, whatever you would like to say. However, if it ends up that the employee works the overtime, you must pay for that overtime. You cannot have a policy that says, if you work overtime without authorization, we will not pay for that time. That would be unlawful and subject you to liability for the unpaid overtime. And you definitely don't want that in writing, nor do you want to do it in application, but you certainly don't want to have that policy in writing. So if they work it, you have to pay it. Hold on, sorry. Okay, wait, sorry. Okay, thanks. This is something that has come up recently. Bonuses do not have to be factored into overtime. Well, that is not true. And this is somewhat complicated because there is something called non-discretionary bonuses and something called discretionary bonuses under the laws. Now, discretionary bonuses are very rare under the law. A discretionary bonus is one that there's really nothing, no formula, no predictability. It's the whim of the company. They just decide that they want to pay people a bonus for some unknown reason, or maybe there's a reason, but it wasn't predicted. Maybe the company got a new contract and something came up and they wanted to pay people a bonus. Well, that's discretionary. That's not what frequently happens, and the definition of discretionary bonus and the interpretation, I should say, of a discretionary bonus under the law is very narrow. So we are talking about non-discretionary bonuses, and that can be bonuses that include company performance, employee performance, a combination of both, you know, based on departmental performance, anything like that where there's some expectation, a reasonable expectation by the employees that they're going to get it, even though the company may not know how much. That's a non-discretionary bonus. And when those non-discretionary bonuses are issued to non-exempt employees, the bonus has to be allocated back over the time period for which it was earned in the weeks in which the employee worked overtime. So if you present an employee with a semi-annual bonus, you would have to look back over those 6 months and identify the weeks in which non-exempt employees worked overtime and allocate the bonus over those weeks. In effect, pro rata. So if there's a $1,000 bonus and they worked, make the numbers easy, they worked overtime in 10 weeks during that 6-month period, so that would be $100 a week extra for each week. You would have to now recalculate their regular rate because now they made an extra $100 for that week effectively, and that would increase their overtime rate. And then you'd have to pay them the difference for the overtime. So, you know, the bonus is one thing. The additional amount for overtime is a separate thing. And that is something that has seemingly gotten more attention lately. So I would highly advise everybody to consider that and make sure you're accounting for that when bonuses are issued. What I like to call out of sight equals out of mind is somewhat of a misconception by people, and that is that that people are out of sight, meaning they're using their devices, tablets, phones on the weekends, at night. And the question is whether the companies are accounting for that time, because that could be time worked. If somebody checks an email for 30 seconds, that's not going to be sufficient. But if somebody's working over the weekend, answering emails, they're on call, that may be work time. So you can manage that by telling non-exempt employees they're not permitted to use their devices after hours or on the weekend. Or if you do allow that, because you may want to have them available, then you should require them to log their time and notify them that if we don't get any indication from you that you worked some time over the weekend, then we will assume you didn't. So it's just make sure that that's being focused on, because many times what happens on the weekend doesn't get contemplated. And then, of course, in that unfortunate circumstance, if somebody files a claim, they will be sure to include that they worked on the weekend and say, I should be paid overtime. So you want to keep track of that. Counting vacation and sick days as part of overtime. You are not required to do that. Overtime is based on hours actually worked in the work week. And if you have a holiday week like this one, and people didn't work on Monday, but you paid them 8 hours, you don't have to count that towards overtime. So if they only worked 8 hours Tuesday through Friday, that would be 32 hours. If they worked an additional 6 hours on Saturday, that would still only be 38 hours, and there'd be no overtime obligation. And that is the same for lunch periods. Bona fide meal periods of like 30 minutes, not work time, even if you pay them. And so that half hour or hour every day should be discounted when calculating work time for overtime purposes. Now, many companies want to include that time and don't deduct it, that's fine. But you don't have to, that is the point. Vacation must be paid upon termination. This is a common misconception, which is not true. Vacation does not have to be paid upon termination. What governs this is the terms of the company's policy. There's no law in New York that requires payment of accrued vacation upon termination. Of course, in any number of this, with this point and some of these others, I'm talking about New York law. If you have employees in other states, things may vary. But in order to take advantage of not paying employees upon termination, you have to have a policy in writing. In fact, it doesn't matter whether you allow or not vacation. New York labor law says that any vacation policy must be in writing. So that's something to keep in mind. And if you do want to prevent employees from being paid out on vacation when they are terminated, then it must be in writing. But if it is in writing, it will be enforced, and you won't have to pay people while they're leaving your company for accrued vacation. If you don't have a policy in writing, then whatever is at issue regarding vacation pay is going to be construed in favor of the employee. So if you say you get 2 weeks vacation and it's January 2nd and they leave and you don't have a policy, it's going to be interpreted that they're entitled to that 2 weeks, because you said we get 2 weeks a year and you didn't define it or put any limits on it. So I'm sure most companies have policies about vacation, but the point that I want to impart here is that you don't have to pay people for their vacation upon termination. And with that, that is our 20 minutes, and that will wrap up my remarks on this last Friday of February. And thank you, everybody, for joining, and have a great weekend, and spring will be here soon. Thank you.